let us move to the discussion. At the beginning of this session, I mentioned that 15 minutes will be assigned to each discussant, but we have only 15 minutes left. Time goes so fast. So may I ask, yes, the organizer told me that we can extend 15 to 20 minutes. So still, each discussant can have 50 minutes to make a comment on the presentation. Our first discussant is Dr. Park Young-gil from Korea Maritime Institute. As far as I know, he is in charge of the Arctic issues and UNCLOS issues in his institute. Dr. Park, please, you have 15 minutes.
Thank you, Chairman. I appreciate Minister of Foreign Affairs, ICLS, and Korean Society of International Law for inviting me as a discussant to this beautiful conference. Nobody doubts that climate change is the most global challenge we face today. As Professor BODANSKY explained very well in his presentation, climate change has a huge impact on every field of the ocean affairs. But one problem is that up to today, we don't have a feasible, effective, or practical mechanism to reduce and regulate the CO2 emission. For example, even though there are several legal regimes such as the Paris Agreement and global leaders promise to achieve zero emission of CO2 by 2040 or 2050, we are not sure we have effective legal regime in the ocean fields to cope with this climate change. Regarding ocean governance, Professor BODANSKY mentioned that until recently, climate and ocean governance largely disconnected. I'd like to ask Professor BODANSKY to elaborate the reasoning of your evaluation on the relations between climate and ocean largely disconnected. Also, I want to ask you to share your idea about the better ocean governance to cope with this, the impacts of climate change challenge on the oceans. Professor Frank has made a presentation about the carbon capture and storage projects. In my opinion, it would be questionable whether CO2 storage can be prohibited under the London Convention or the Protocol. The London Convention prohibits the disposal of all wastes specified in Annex 1. Although CO2 may not be considered waste under the convention, but it can be fall under the industrial waste category in the Annex 1. So if CO2 is considered as a waste or industrial waste, then CO2 storage in the ocean will not be possible under the London Convention or Protocol because dumping CO2 is be prohibited. The definition of dumping in the Convention and Protocol refers to waste or other matter. Therefore, it seems reasonable to interpret the term waste and other matter to include CO2. So I want to ask Professor Frankus if there is any room to interpret differently the term waste and other matters or dumping in the London Convention and the London Protocol in terms of the Vienna Convention on the Law of the Sea. London Convention and the London the Protocol intends to protect the marine environment from dumping the waste and other metals into the oceans. And the purpose of the CO2 storage activities is to protect the ocean from the impacts of the climate change. So my question is if there is any room to interpret differently the term in the convention and the protocol. Professor VIDAS made a comprehensive presentation about the question of sea level rise and its implication to the international law. It is very helpful to understand the legal implications and the relations between sea level rise and the law of the sea. The impact of sea level rise varies and different from countries to countries, I think. Because of sea level rise, the baselines can move towards the land, and this may cause the questions of changing the limits of territorial sea, EEZ, and the continental shelf. In this case, while coastal states may want to maintain its existing lines, the other states may request to change the lines. This kind of state practice may contribute to establish a new customary international law, maybe. But because of the impact of the sea level rise, some small countries in the Pacific Ocean and the Indian Ocean, they fear about the disappearance of their existence. So I want to have one question to Professor VIDAS. What I am wondering is that if there is a way to bring the countries producing a huge amount of CO2 into the air, or the whole global community to be responsible under the current international legal regime. If not, is it a practical idea to ask the ILA Committee on the Sea Level Rise and international law and ILC to deal with this agenda? This is my final questions. This is all for my discussion. Thank you very much for your kind attention.
Thank you, Dr. Park. Let me ask our next and the last participant, Dr. Kim Wonhee, who currently works for Korea Institute of Ocean Science and Technology. May I ask your comments on the presentation?
Thank you, Moderator. I'd like to express my sincere gratitude for inviting me to this wonderful conference and to the organizers, 3 organizing institutes, and Ministry of Foreign Affairs of Korea and International Tribunal for the Law of the Sea and Korean Society of International Law. At first I was invited. I could not resist accepting the invitation when I read the theme of the conference, the Law of the Sea for the Next Generation. I have found it very interesting. The fourth session is directly relating to the Law of the Sea for the Next Generation issues, sea level rise, and then climate change issue. So I learned a great deal from 3 speakers, and I found it not many things to add, but I'd like to ask some question and comment on the 3 speakers' presentation. Firstly, I'd like to ask Professor BODANSKY about the disconnected phenomenon of the climate law and ocean law. So I found there are some discrepancy of the operating mechanism between the ocean law and the climate law, because since the failure of the Kyoto Protocol system, the climate law has been evolved in to taking the bottom-up approach and a more soft law approach. So, however, on the other hand, the Law of the Sea Convention, the United Nations Convention on the Law of the Sea, has been a very hard law approach, and they adopting the compulsory dispute settlement mechanism. So do you think this kind of a different operating mechanism could be complemented each other? Or, so as you already answered negative to the how the ocean law play a role in promoting the mitigation of the, you already answered in the negative form. So do you think that discrepancy could aggravate the disconnected phenomenon of the two legal systems? This is my first question. And secondly, I'd like to ask about the real challenges of the marine protected area in the high seas. So I think there will be no scientists and lawyers who are disagreeing with the importance of the designating the MPA on the high seas or other maritime area. However, when we go into more administrative or practical matters, like who will trigger the mechanism of the designating the MPA in the high seas, and also who will decide to where designated the MPA in the high seas, and then the most important part, who will pay? How can we share the burden of the designating the MPA in the high seas? It is a very huge challenges, because when you explain the MPA systems which are working very well in the particular sensitive area designated by the IMO, and also the Antarctic Treaty System in the special area designated by the consultative parties of the Antarctic treaties, they have a very, how can I say, the most specially affected states are coming together, and they are coming to the terms of how they will designate the MPA and to monitor and surveil the maintenance of the MPA. But when we think about the designating the MPA on the high seas and monitoring, surveilling, I think it will be very huge challenges. And also, especially there are very small number of maritime powers who can monitor or survey the marine protected area in the high seas. This is my second question. My third question goes to Professor BODANSKY as well as Professor VIDAS. So at the end of the last October, Antigua and Barbuda and Tuvalu signed an agreement to establish a commission for climate change and international law, and they gave a mandate to bring the advisory opinion, to request an advisory opinion before the International Tribunal for the Law of the Sea about the rights and obligation of the state parties concerning the climate change issue. So I'd like to ask you, how do you expect, if they bring the advisory opinion case before the ICLS, and if the ICLS answered they're making some answer to that questions, so how do you expect the outcome or influence of the advisory opinion? This is the question directing to two speakers. And secondly, I'd like to ask Professor Benkis about some obligation under the convention with regard to the carbon capture and storage. You mentioned some obligation of the due regard obligation, but is it possible to include one more obligation like environment impact assessment under the Article 204 of the convention? According to the convention, it provides the obligation to endeavor as far as practicable to observe, measure, evaluate, and analyze by recognized scientific methods the risk or effects of the pollution of the marine environment. And also the paragraph 2, it provides that in particular, states shall keep under surveillance the effects of any activities which they permit or in which they engage in order to determine whether these activities are likely to pollute the marine environment. So I found it very relevant obligation with regard to the carbon capture and storage of the EIA. So this is my question directed to Professor Benkis. That's all my question and comments. Thank you.
Thank you, Dr. Kim. Even though 100 minutes assigned to this session, have fully elapsed. I think we need more time to respond to the questions raised by discussant. I'd like to ask each presenter to give answers to the questions raised by discussant in the very compact manner. Yeah, thank you. I'd like to ask Professor BODANSKY first.
Well, thank you very much, and thank you for those very interesting and thoughtful questions. I think the questions are likely to be better than my responses to the questions. So let me start with the hard law, soft law question. So I think the climate change regime started with the assumption that it would take a harder law approach like the Montreal Protocol, and the Kyoto Protocol was the attempt by the climate change regime to pursue that route. But I think as the Kyoto Protocol's ultimate failure suggests, dealing with climate change through that kind of hard law approach is, at least at this stage in international relations, unlikely to succeed. Climate change implicates virtually every part of a country's economy, its energy system, its transportation system, its agricultural system, and trying to get countries to change their economies fundamentally through hard law, I think, is a heavier lift than international law is able to accomplish. So I think that's the reason why states have now moved towards a much more facilitative, lighter approach in the Paris Agreement. Whether that's going to be successful, I think, is an open question. But I think so far, at least, it is proving more successful than the Kyoto Protocol did. I think that relates to the question you asked about the advisory opinion that ICLS might be requested to give, and it might provide an advisory opinion. What kind of effect would that have? I think it would certainly be help shape expectations. It would certainly provide an argument, well, depending, of course, how the opinion comes out, which I wouldn't want to predict, but could provide an argument within the negotiations. I think it's unlikely to change the fundamental dynamic in the negotiations. So I think I liken the negotiations to a process of trench warfare where countries are battling each other, moving backwards and forwards a few inches. So I think it would provide certainly an argument in that process, in that negotiating process, but I guess I think it's no more likely to succeed in fundamentally getting countries to change their behavior than the Kyoto Protocol was. So on the question of how to better integrate climate and ocean issues, I think a lot actually depends on national governments. National governments are largely siloed, where different people are going to different negotiating forums, fisheries, marine issues, climate, and I think trying to have better integration within national governments is a starting point to try to get better integration of climate, ocean issues internationally. I think, as I suggested, there's a problem on the climate change side, of course, that it doesn't sufficiently take into account ocean issues, but there's an equal problem on the ocean side in fisheries, marine protected areas, of not taking into account adequately climate issues. On the question as to how to designate, who would designate MPAs and enforce them, I don't know the answer to that. That's, I guess, what's being discussed now in the BBNJ negotiations. There's suggestions to have the COP be the one that would designate. I think there's still a long way off of reaching any agreement on that, and I don't have an answer, so sorry. Thank you.
Thank you. And next, Professor Banks, please.
Yes, and thank you to both discussants for raising interesting questions. As to the first, I think the question was, is there an issue with the industrial waste prohibition in relation to the London Convention? I think that there is. I don't think that all industrial processes producing carbon dioxide would be caught, but I think the practical solution for a state concerned about the London Convention, I think, would simply be to ratify the protocol. And since the protocol now addresses the possibility of CCS activities and clearly allows it as long as there's compliance with the guidelines, it seems to me that's the practical solution going forward. And I don't think there's then any need to engage in purposive, interpretive exercises, because, as I say, the amendment to permit CCS under the protocol has already entered into force. So in a sense, the parties themselves decided this was an important issue, they needed to resolve it. As to the question about EIA in relation to CCS activities, I think that's Article 206, I think it is certainly applicable. And interestingly, if one looks at Norway's CCS regulations, they clearly provide for the undertaking of EIAs. And as Norway is a party to the Espoo Convention, the regulations also address EIA responsibilities under the Espoo Convention. So a good point and certainly applicable. Thank you.
Thank you. And next to be Professor VIDAS, please.
Thank you very much, Mr. Chair, for inviting me back to this virtual floor. I will be very brief, but I want to thank to Dr. Park and Dr. Kim for asking what are at the same time fundamental and timely questions. And I think that they are also interrelated partly, even though this might not be apparent at the first sight. The question by Dr. Park was about responsibility, whether we could discuss and establish responsibility of some countries for what I would say is Earth system change or part of Earth system change, such as through increasing the global emissions and CO2 in the atmosphere and all what it causes in a chain of the Earth system reactions. Well, I think that in terms of legal responsibility, we may have difficulties in establishing a causal link. And there are quite some complex questions here. However, I think that in terms of political responsibility, understood in a broad and targeted sense, there may be a chance. And this chance may be reflected in an agreed interpretation of UNCLOS. And I think that the declaration which I've been quoting and presenting from could provide some inspiration to this effect. It is a document at the table, at least. And in a way, I would say that this is also a response to the question by Dr. Kim, even though this was a very specific question about advisory opinions. But let us see what the next months and years will bring and how the states might come to reflect their subsequent practice so far in terms of interpreting UNCLOS under those very special conditions of climate change related sea level rise. So thank you very much. I think that would be my response.
Thank you very much for your answers. And I'm very sorry that we cannot have further in-depth discussion because of limited time. And I'd like to end this fourth session with express my appreciation to three speakers who delivered very insightful presentation and two discussants and an online participant. Thank you very much. The session completed.